I'm James Dapperchi, and this is Coffee and a Case Note. Guys, today we're going to have a chat about a very exciting subject, third-party breaches of confidence. So the plaintiff we're discussing today is essentially chasing a micro-blogging website that you might have heard of to seek two things. Firstly, an injunction, and secondly, a Norwich order. We're going to work through what happens. So this is the decision of X and Twitter. Right. Twitter, you'll be familiar with. It's a micro-blogging website that allows its users to post statuses and allows other users to engage with those statuses. And it's published sort of all over the world. I think at the time of the judgment, there were about 300 million users. So lots of people on there. But what started to happen was that the plaintiff's confidential information began to be published. Now, the first publication was from a Twitter account falsely using the plaintiff's CEO's identity to publish really sensitive, confidential financial information on Twitter. So the plaintiffs complained, Twitter immediately took it down. Happened again a couple of weeks later with an account user who used one of the senior officers' names. The plaintiff complained, confidential information was taken down. Now, what also happened was the plaintiff said, now look Twitter, there's someone publishing, we want to know who it is. Disclose the identity, please, of the people who are making these publications. And Twitter said, until there is a legal compunction for us to do it, we're not going to do it. So, there's another publication, and there's more material thrown up on Twitter, and the plaintiffs are left with little alternative but to commence proceedings, which is what they go ahead and do. And as I flagged earlier, what they seek is an injunction to stop Twitter allowing this stuff to be published and to take it down. The second thing they seek is a Norwich order, and that Norwich is a word from a mid-70s English decision that we can talk about another time, perhaps on another Coffee and Case Note. Now, in relation to the injunction, the fundamental relevant law that is the focus of it is that a third party who holds confidential information that has been obtained unlawfully and is aware that confidence attaches to that information has the same duty of confidence in respect of it. So Twitter found out that the information was confidential, and once Twitter became imbued with that knowledge, it had the duty of confidence in respect of it. So that meant that the plaintiff was able to prosecute its pursuit of an injunction on that basis. Now, it did so, and Twitter's response was interesting. It didn't appear in the proceedings, and it sent an intriguing email that explained that it did not submit to the jurisdiction of the Supreme Court of New South Wales, which is a very interesting and, as the judge hearing the matter said, somewhat heroic thing for it to do. Now, firstly, judgments of the Supreme Court of New South Wales can apply to entities who are outside of New South Wales, as Twitter was to learn, and then more substantially, the judge was inclined to grant the injunctive relief sought by the plaintiffs in these proceedings. And it did so on a number of bases. Firstly, Twitter made its submission in its little email from its support team to say that, it's not feasible for us to try to prevent these publications. Well, what the plaintiff said was, that's all well and good, but you're not here in court to explain that to us. So, so we don't have the benefit of your evidence to understand that. What the judge also found was that Twitter, including in its annual report to the SEC, holds itself out as being very interested in taking down spam accounts, looking after privacy, and complying with relevant laws. And so, if that is in Twitter's commercial interest, then it is in Twitter's commercial interest to comply with orders of this kind. And so the judge found, for those reasons and others, that the injunctions ought to be granted pretty much in the form the plaintiff sought. So we can tick that box. Injunctions granted. The plaintiffs then wanted to say, right, we've got Twitter out of the way, now we need to find out who is publishing this stuff. So they found out, they turned their attention to the decision of Norwich. They set out the relevant issues, including that Twitter had become mixed up in the knowledge of who had committed a wrongdoing, and The judge found that, yes, the Norwich orders would be granted, and so the identity of the wrongdoers would be delivered up. Now, let's just reflect on what our plaintiffs have achieved. They've got their injunction. Twitter cannot publish that stuff anymore worldwide because the jurisdiction of the Supreme Court of New South Wales is not geographically restricted, and the injunctions apply in personam to the Twitter entities. Injunction done. Next, Norwich. Can we get the identities of these people? Yes. Big tick in that box. Twitter's become mixed up in knowing the identity of people who've done something wrong. And so Twitter are obliged to deliver up those identifying factors. And so, despite the fact Twitter didn't appear, our plaintiffs also got up on costs. So we got a tick for the injunction, we got a nice juicy tick for the Norwich orders, we got a nice tick for costs. And I hope that reflection assisted you. It may assist you in advising your clients who find themselves in a tricky spot with something that's been published online. That's it for us today, and I hope soon you'll join us for another coffee and another case note. Thanks very much.